Hello, my name is Richard Lighthouse. I'm with the group Targeted Justice. We are a 501c3 nonprofit organization founded in December 2017 in Texas. And we have an important announcement to make, and we've got some folks that would like to say a few things. First of all, we want to thank Dr. Lynn Bear in Chicago for helping us arrange this meeting and announcement. Also joining me today will be Anna Toledo. She is on the board of directors of Targeted Justice, and she is also an attorney that is representing Targeted Justice and a number of plaintiffs in this important lawsuit. Let me give you a little background on Targeted Justice. We are the world's largest support organization for targeted individuals in Havana syndrome. We currently have more than 3,500 members worldwide. We have a newsletter that is available at targetedjustice.substack.com. I encourage you to sign up for that newsletter. And we have spent many years researching the history, the weaponry, the technology, and the legal issues around the targeting program that is funded by the CIA. Let me now introduce you to Anna Toledo, and she has been leading this effort, very important lawsuit for Targeted Justice. Thank you.
Good morning. Good morning to everybody. I wanted to answer some of the questions that people have been having regarding this such important lawsuit that so many people have waited for so long. So I'm going to address some of the questions that were channeled to me. And the first being, why did we file it in Texas? Well, Targeted Justice is a Texas corporation, and many of its members are here and it's volunteers. Targeted Justice works primarily with the aid of volunteers. And 10, maybe 11 of the plaintiffs live here. So that's in judicial terms, it's called venue. Venue is proper where most of the acts occur. And that's where the volunteers and the plaintiffs that have sustained damages and that are listed in the terrorist screening database as non-investigative subjects are. So it's a purely legal reason for all Article 3 courts have jurisdiction over the matter. Regarding how this lawsuit is different from prior ones, well, there's two prongs to that. First is the lawsuits that have challenged the watch list per se. Many talk about the watch list, and it wasn't until I delved into this that I realized that there are various components to that watch list. And if you take the time to read the 99 pages of the complaint, which are not that complicated, you will decipher what this is about. But in general terms, what the FBI people that have appeared in prior cases have said is this. It contains three main components: the known terrorist, the suspected terrorist, and then there's a category of people that are none of the prior ones. This instrument was created supposedly to combat terrorism, and we have declarations under penalty of perjury from people that have been represented the agencies in those cases that say that this instrument hasn't really deterred any terrorism or accomplished much in that sense. But the important thing and what concerns targeted individuals is that the non-investigative subject category of it has never been challenged in court. And that's what we're challenging, because that's where they get the list to do the experimentation, illegal, non-consensual experimentation on human beings, which is all of the TIs. That's why this lawsuit is so important for all TIs, because in the prior cases, the Court of Appeals have held that Congress has provided a method of redress for the people that are in the list. Is the watch list component of the list said by, told by FBI agents is the known and suspected terrorists. But for non-investigative subjects, they're not supposed to know that they're on that list of non-investigative subjects that comprises 97% of the database. Said by, it's important that you note, I have to say probably 90%, I haven't counted them, but most of the statements of fact that are set forth in the complaint come from statements under penalty of perjury by FBI agents in other litigation. I didn't make any of it up. In fact, in many occasions, I cited exactly the deposition statement or the statement in a document. So I didn't make any of the stuff up that's there. So courts have not had the opportunity to review what it is to be put in a list where you are, put in a list for some nefarious reason. You are not given notice of it. You're not given an opportunity to challenge it, and you're not given an opportunity to get out of it. And that's one difference from the prior cases, because in the prior cases, it said Congress has provided redress proceedings for the people that are known or suspected terrorists. Why did they know they were in the list? Because they tried to travel and they couldn't travel. As we all know, NIS, us, we can travel around, or we can get, a license for a gun or whatever. And we don't get that much trouble because we're not terrorists. We're not associated with terrorism, but we're just put in that list. So that's one aspect. The other aspect is that the individual TI cases, I haven't reviewed all of them, but it is my opinion that probably most of them were dismissed because of that almost impenetrable wall of plausible deniability, which in this case cannot hold itself because we have a lot of targeted, hundreds of targeted justice members saying the same thing the plaintiffs are saying. So here you have a situation where not everybody can make these outrageous things up. It's just not possible. Mathematics, it's just not possible. So it can no longer, they got so greedy putting people in this program that it's no longer deniable. And when you look at, for example, in Twitter or the hashtags, you have over 1,000 tweets a day on targeted individuals. This is a thing. It can no longer be hidden because it's real. It can no longer be denied. So that's what the main things that are different. The other thing is that when you go to cut a tree, you cut the trunk, right? And not the roots and not the branches, because if you prune the branches, it grows bigger eventually. So we just have to go to the trunk, and the trunk is the terrorist screening database, because that is where they get the names of the people that they are going to subject to torture for the rest of their lives. And that's what we're going for. We believe that that's why this should benefit in the long run all TIs, because once we have the court declare this atrocious list that for no reason we're in that list other than improper motives, well, when we can have it declared unconstitutional, it'll benefit TIs across the nation, probably across the world, even though it is only American citizens that are protected by the Constitution of the United States. There are many constitutional pleadings. We have included First Amendment. We have included, freedom that we have been included in the list as a punishment for exercising our First Amendment rights. We include the Fourth Amendment, which is a legal seizure, search and seizure. We included in the complaint allegations about how all of our electronic communications are illegally surveyed. We include the deprivation of property without due process. We include the cruel and unusual punishment that constitutes the PSYOPs of the organized stalking and the directed energy weapons and the V2K. So even though we're not including like the gazillion symptoms and effects of targeting on people, we are including in general terms what most TIs suffer. So that's how it's different, because it's not a complaint yes, we have 17 plaintiffs, and that's and that has a legal reason and strategic reason. Well, I'm not going to talk about it, but the important thing is that it's the redress we seek is to benefit everyone in the community, even those that are not targeted justice members. Although what we seek to obtain is also the nomination forms. Since we were improperly placed in that list, we're alleging we have a right to see the nomination forms for all of targeted justice members and the plaintiffs. How we got into this place where we are. Okay, so what are we asking for? Well, we're asking for the list to be declared unconstitutional. It's an unconstitutional use of power. Billions of dollars of American taxpayer money are being used to torture your fellow Americans, and that's illegal. We are also going to establish how the moment the person was placed on the list was when their targeting and the symptoms began. And that is key. That is key because that's why we, are asking for access to see that list. We're asking for that list not only to be declared unconstitutional, but to be withdrawn. We called from the over 18,000 agencies, it's state, federal, tribal governments, corporations, and individuals that have this list. So we're asking for it to be recalled from all of those places. And of course, we're asking for damages for these plaintiffs that are, in a sense, going to establish the damages that each one sustains as a TI, because if they didn't ask for damages, well, they would renounce them, right? It is very important that people know that some of the plaintiffs have received derogatory comments, or they have been berated because, oh yeah, you're in the complaint. Well, you should know that these are frontline soldiers, that the directed energy attacks on them have been intensified in duration and strength, and they are having a terrible time. And the reason we chose these plaintiffs, not only because they are committed to targeted justice cause, not only because they're TIs, but also because they knew that they were going to undergo severe attacks, and they are committed to fighting for all TIs, and they are undergoing severe attacks for the benefit of everybody. So you should have, bear that in mind and try to not judge about it. Then some people have asked, how are you certain that this case won't be dismissed? Well, I cannot assure anybody that, because that is for the court to determine if we prove our case, right? And we bring the evidence. But what I can assure you is that complaint has over 500 hours of work, but it's not just writing, but it's reading the prior cases, reading the evidence on prior cases and prior statements. So it's based on what attorneys call uncontroverted facts that the defendants cannot defeat because they come from the defendants, from evidence that they have provided before. So they cannot contradict themselves. They're not supposed to contradict themselves. Regarding whether other people can join or not, well, all I'm saying is this. We want to expedite this. We have asked for various remedies, including injunction, which is the removal, just declaring this list unconstitutional and retrieving it, but also preventing these agencies from making other lists that are equally, nefarious. We're asking for the court to, and of course that's for the court to determine, to impose a court monitor for, let's say, over a year after the case is over, when we prevail, because we want to make sure that throughout the nation, the all the organized stalking and the directed energy weapons attacks and the V2K, everything stops throughout the nation, not just for the people in Texas, not just for our plaintiffs. And that's one of the things we're asking for. It's basically a national injunction asking for this to stop at a national level, protecting the rights, the constitutional rights of American citizens and legal residents. No one should be subjected to torture anywhere in the world, let alone in the United States, with American taxpayer money. And at this stage, that's why I think that when we prevail, it'll open the door for many TIs throughout the United States, because this will set the basis for them to seek their redress or their damages. But, complicating things up now, I think would only, it's a very expensive process. Anybody that litigates in federal court knows how extremely expensive it is. So, it's up to the people to decide. I do ask for unity in the TI community, because all we ask for is just living in peace, being able to live and sleep and lead a normal life without the inconveniences and the torture and the psyops. And if all TIs unite supporting targeted justice, regarding of whether or not you're a member, it's just, this is a cause that is going to benefit everybody. So if you want to be rid of your targeting, the least you could do is not criticize if you don't have a reason to do so. Study, read the complaint, and be certain that if you make a statement, it's based on true facts, not false accusations of any kind. The best way to follow the case is certainly either in the Targeted Justice webpage, just targetedjustice.com, or in the Targeted Justice Substack newsletter. We're writing frequently there about the updates to the case, and I think that's the best way. If you have any questions, you can send us a question to the Targeted Justice email, which is tjustice2, tjustice2@proton.me. And then we can probably address it. If we get a lot of it, we can, of those same questions, we can address it in a newsletter. Bear in mind that all of our communications, all TI communications, all targeted justice communications are intercepted. And so sometimes we might not get it. So just try through other means. How can people help? Well, from my side, I just said it, just show support by being, solidarity. Just give us the solidarity. It doesn't take much, and it means a lot, because the division within the community will only perpetuate your targeting. And share this video with more than the TIs. Share them with what I call normies, with people that have no idea that this is going on in the United States and the world. That's the people that need to wake up and realize of this extremely illegal program that mimics the MK Ultra. It's a combination of the COINTELPRO and the MK Ultra. As a Puerto Rican, I am very identified with the COINTELPRO program, because they destroyed the lives of many, doing the same gang stalking techniques, organized stalking techniques that they do to TIs here. And in Puerto Rico, well, it was a huge case, and they had to pay money, not significant amount of money, but to a lot of people. And I think that, and the FBI publicly apologized for it, only to come and do it again in this other disguise program. So that's just, any other questions, just send them to the email. And I think that I'm gonna pass to Richard to say some words, but please share this video and spread the word. That's all I have to say.
This is Richard Lighthouse again. I just wanted to thank Anna Toledo and Dr. Len Baer for helping us arrange this brief conference. And if you've got questions, please forward them to tjustice2@proton.me, and our volunteers will try to get you as quickly as possible. Please understand we are very backlogged on our emails, and our volunteers are working vigorously to try to get your questions answered, so please be patient. If you'd like to support Targeted Justice, please consider a donation. You can go to patreon.com/Targeted Justice. We also have a link on the Cornerstone application and website, which is available on our homepage and the donation tab. So please consider a donation. Thank you again to Ann and Len, and we look forward to speaking with you and get you an update as soon as possible. Thank you.